Okay, this is another topical issue. The Human Rights Act. What is it and why it doesn't work? I actually did my extended essay on this, and my conclusions with the human rights regime in the UK had been a total abject failure. It doesn't work. Uh, and there's a lot of misconceptions about the Human Rights Act and the European Court of Human Rights. So I'm going to blast through that quickly and then go on to why it doesn't work and should be removed. So basically, after the Second World War, the UK and numerous other European countries rather, decided we need a standard of human rights recognised throughout the continent to try and prevent or slow down the absolute insanity of the rise of the Third Reich and communism and everything else. So that was the Human Rights Convention. The parties that signed up to this were part of an organisation called the Council of Europe, not the European Union. Now, it doesn't help that the Council of Europe has the exact same flag as the European Union, but it's a separate entity. I mean, it had former members like Russia and Belarus and other countries in it. So, that was a treaty which the UK signed up to, I think, in 1950 odd. Now, the way treaties work in the UK is quite interesting. We are what is called a dualist jurisdiction. What does that mean? Dualist jurisdiction is where international law has no existence within the UK jurisdiction unless our own domestic law recognises it. So the treaty was signed up to, but we would call unincorporated. That basically means that it wasn't transformed into an act of parliament. It didn't have the force of law. What it was used for was as persuasive authority in the process of statutory interpretation where such legislation was ambiguous. What the hell does that mean? Basically means that we have a body of rules when trying to work out what legislation means, and one of them is that treaties can be used to clarify things. So, famous case, I can't remember what it was, but it was something like some guy was detained under terrorism legislation in the 70s, and the issue was, what does the word detention mean? And they said, well, clearly the meaning of the word detention is in accordance with the Human Rights Convention, which says you can't have unfair treatment, yada, yada, yada. So it added substance to a grey area. That's all the Human Rights Convention could do at that time. It's a policy document. Yes, you could take cases to the ECHR, but you need permission of the domestic courts. What the Human Rights Act did is it transferred the substance of the convention found in the treaty into domestic law, and it became an act of parliament. And it basically put a duty on judges to interpret all other law previous and post 1998 to be interpreted so far as is possible to be in concordance with the rights, with the convention rights. But it couldn't change legislation. They didn't give judges, courts, the power to set aside one law if it conflicted with the Human Rights Act. And this is something that the left and the liberals get totally wrong. They think the Human Rights Act is like an American Bill of Rights, where if the Senate and Congress come up with a law and if it conflicts with the Bill of Rights, judges have the power to set the problematic law aside. That is not what the Human Rights Act does. It's just a guide to interpretation. It's that all laws should be read with the flavour of and the colour of the Human Rights Convention. But if legislation is clear, and it's clear in the way that it conflicts, older legislation cannot retroactively or proactively rewrite future legislation, so you're stuck. So the human rights system is very, very weak in the UK because we don't have a system of permanent or entrenched law. Every Act of Parliament is just as powerful as every other Act of Parliament, and where two conflict, the newer Act of Parliament always wins. Implied or express repeal. So that's basically it. These liberals that hold up the Human Rights Act, and very few of them have read it, funny enough, as this sort of holy writ handed down to us by the great sages of old. None shall be added to or taken from the word. It doesn't work like that. It can't work like that because the way of our system. They want it to work like that, and the judiciary and the left-wing liberal judges have, absolutely strained the system as much as they can to try and turn the Human Rights Act into some sort of constitutional document, but they failed. And this is why the Human Rights Act it's an irrelevance. The biggest problem of it is that it has been totally used and abused by the legal industry and perverted for uses that it was never designed to accommodate. The Human Rights Act was designed to stop men in balaclavas banging on your door at 2 a.m. saying, "Get in the truck, don't ask questions." It was designed to stop the runaway powers of the state. It was not designed to ban the deportation of serial child molesters. Saying that, you can't deport foreign criminals because his son likes chicken nuggets, whatever the hell it was. It was never intended for that. So the legal industry have done it because it's part of the larger immigration industry. They want to make a lot of money out of banning or blocking deportations, and the Human Rights Act was the only tool they had. So they developed it into this monstrosity. And I say to lawyers, they love to think it's your own fault. If you were so unreasonable, if you push and push and push, we're going to push back. And there's that one. The other problem, of course, is that there's a notion of jurisdiction. Why is a foreign court with a lot of wacky and weird judges in it telling us what to do? We don't, that's not the way normal countries behave. And the other thing is that we had a perfectly valid system of rights protection in the UK before the Human Rights Act, and this is something that the Liberals don't get either. They're very European in their legal jurisprudence, and that they think that a human being has no legal value unless the state says so. That may be how they did things in ancient Rome, but that's not how we do things in the UK. In the UK, everything is legal unless the law says otherwise. So that's called residual freedom. So this idea that we were dependent on the Human Rights Act to save us from our barbarity is nonsense. I think we all agree that we have far fewer freedoms today than we did in 1998. The Human Rights Act was absolutely useless in preventing all of the Blairite terrorist legislation. It was absolutely useless in the abolition of fair trials, when previous convictions could be used as evidence against you. Didn't do a damn thing. But they deify it. It's part of this liberal international that they've been sold on. They're very wrong, and the vast majority of the liberals that love it have never even read the damn thing, and they certainly haven't read the Section 3 of the Act that limits its power. They really don't like that when you cite that back to them. So, the way the system worked before the Human Rights Act is that protection of rights was not just found in one document. It was the systemic nature of the entire legal, legislative, and executive system. It wasn't just something bolted on. And this is why most written constitutions throughout the world have protection of rights written into them, and most of them fail. The North Korean constitution promises life, liberty, and the pursuit of happiness, but that's an abject failure because the system isn't interested in that. The British legal and judicial system had protection of rights ingrained in it from the front door, to the 11th hour. Just off the top of my head, firstly, we have many other ways of protecting freedoms without that silly act of Parliament called the Human Rights Act. So, for example, the fact that we don't do entrenched legislation. So bad laws can be removed very quickly and easily. We have representative democracy. We have a vast amount of reserve powers in the monarch. The monarchs, should they choose, and they have now occasionally, can deny the passage of a bill through Parliament, and if it gets through Parliament, they can veto the thing through the denial of royal assent. We have a bicameral legislature, which means we have not one house but two houses. So if the Commons loses its mind, which it obviously has, the theory is that the Lords can act as a brake and stop it. We have the rights of appeal. So when the courts get things wrong, and they often do, we can appeal the ruling. We can take the state to court through an action of judicial review, where the decision-making process can be reviewed by judges. We have a whole body of tort, whereby you can sue the government for harming you. We have the right to be judged by our peers in terms of criminal cases, the majority of criminal cases. Juries can throw out cases. I say throw out. They can use a thing called jury equity or jury nullification, which is where if the judge says he's legally guilty, the jury say no, he's not guilty. He hasn't done anything wrong. Clive Ponting was a famous example. Likewise, the judge can throw out a case if he thinks there's serious irregularities with it. That's the tip of the iceberg. There's probably other. We have public hearings. We have public trials. We have the law reports that publicly displayed. We have technically an independent legal professionals, barristers and solicitors. There's a ton of other things I've forgotten, but that's where the protection of our rights came from. The whole system had checks, balances, reviews, pressure release systems, you name it. And we really didn't need an incorporated treaty from the 1950s to tell us that. And the final thing I've just remembered is that this is what few people understand, is that the Human Rights Convention, which is the core of the Human Rights Act, was not written from the perspective of a common law legal tradition. It was written predominantly to serve European legal systems. That is a serious, serious problem, because common law jurisdictions, we read legislation very differently than what they do in France and Germany and Poland. In their system, there is very little scope for statutory interpretation. The courts don't look at what the legislation says. What does this mean? What does that mean? The prosecution and defence don't argue over what does this word mean? What does that mean? The law is as it is, and it's given the plain, simple reading for it. And this is often dependent on the views of various academics. In the common law tradition, we're the total opposite. We put the law on trial. We interrogate the law. What does incarceration mean? Well, what did Parliament mean when it's setting? So, because the Human Rights Convention was written very loosely and with the imprecision, that caused all manner of problems and gave the wiggle room for the judges to put whatever they like into it. Whereas in the continent, that was less so, because judges, they're just code enforcement officers. Okay, I think that'll do.